This case, heard in the Irish Court of Chancery, examined a complicated farming lease. Yielding had leased land to the Harnett family for 21 years at £85 a year, with a guarantee of renewed 21-year leases for the rest of Yielding's life. Years later, Harnett surrendered the lease because the rent was too high. Yielding offered the Harnetts another 21-year lease at the lower price of £80 per year. They took it. More years later, Harnett's son, who was by then farming the land, applied for the lease to be renewed, and this was rejected. Yielding said the new lease was simply a 21-year lease without the guaranteed renewal. Harnett Jr. took the matter to a court of equity seeking specific performance. That is, he wanted an order that the lease did include the renewals and that a new 21-year lease must be granted. The Lord Chancellor took the opportunity to set out some fundamental principles about specific performance. He wasn't making new law, but rather setting out in one place the existing principles as he understood them. He started by stating the basic principle of specific performance. Unquestionably, the original foundation was simply this, that damages at law would not give the party the compensation to which he was entitled, that is, would not put him in a situation as beneficial to him as if the agreement were specifically performed. In addition, though, he set out 3 circumstances in which specific performance would not be granted. The first was if the plaintiff was in any way blameworthy. He said, the party who comes into equity for a specific performance must come with perfect propriety of conduct, otherwise they will leave him to his remedy at law. Second, the specific performance itself had to be lawful. He said, he must also show that in seeking the performance, he does not call upon the other party to do an act which he is not lawfully competent to do. Finally, he said that certainty of the act to be performed was crucial. Specific performance would not be granted when, from the circumstances, it is doubtful whether the party meant to contract to the extent that he is sought to be charged. This last rule decided this case. It was not certain whether the new lease included a renewal clause, and so specific performance was not granted.